I'll start off by saying, like, the law in Canada is not, there's no implied consent.
And you want to attack the inconsistencies, you want to attack the changing stories, and you want to do it for the best interest of your client.
They're one of the boys. They wanted to give these boys a break. They were just having a good time.
Do you see any threat to the presumption of innocence? So, Kate, last month in April, we saw the start of a criminal trial in London, Ontario, the Hockey Canada sexual assault trial, which has been very publicized, sensationalized, a lot of media coverage, which is unusual in Canada. A couple of months ago, we were talking about how after the O.J. Simpson trial concluded in the U.S., the prosecutors wanted Oprah Winfrey, and how you told me that that would never happen in Canada. But for Canadian standards, this trial is actually fairly in the spotlight. So this is right up your alley because you've prosecuted sexual assault claims, you've defended sexual assault claims. So what is this particular case about?
So this case involves an allegation from 2018 involving currently 5 members of the of Canada's hockey team. They had won a championship. They were in London, Ontario for a celebration. They got rings similar to Stanley Cup rings or Super Bowl rings. And after that celebration, they'd went out and they ended up in a hotel room with a number of their teammates and one woman who's identified only by her initials, EM. And a number of sexual acts took place. And as a result of that, she ultimately ended up going to the police on more than one occasion and filing a civil suit, which kind of brought this all to light. So originally there was no charges, but because of quite a bit of public outrage, the case was reopened. Charges were laid against these 5 individuals, I think all of whom were in the NHL at the time. They were removed from the NHL, and now their trials actually started.
Right. And I think looking specifically at the facts, it's somewhat similar to, it reminded me of the Duke University lacrosse team case that happened almost 20 years ago now, where you have one complainant making allegations against a group of athletes about sexual assault. But I think there's some distinctions between that case and this case, which might possibly result in a different outcome in the Hockey Canada trial. It's my understanding that what happened is that this complainant had a consensual interaction with one player, and then that player then brought a group of his friends afterwards who then thought that they could also engage in sexual acts with this complainant. Is that sort of the case?
So, I mean, as is the case with most sexual assault cases, it's very much he said, she said in this case, except there's 1 she said and 5 he said, because there's 5 people who are currently on trial. But essentially, yes, so they were, I think there was 3 of them. I might not have that number right, but a number of them went to a bar called Jack's in London because some of them weren't old enough to drink in Ontario and some of them were. So there was at least 2 of them that went to this bar. That's where they met EM. And EM left with Mr. McLeod. She calls him Mikey. That's what they call him in the trial. Mr. McLeod, and they went back to Mr. McLeod's hotel room and had consensual intercourse, just the 2 of them. When that was done, there's a number of text messages that are described in the trial. One of them is saying, hey, there's food here. You can come here and get food. And there's one that goes out to one of the co-accused saying, do you want to come have a threesome in a group chat? And somebody responds and says, yeah, I'll come back to the hotel. And they all end up in the room. And so at one point, I think in her civil suit, there's at least 8 people who are listed as being in the room when she's there, although only 5 of them have ultimately been charged.
Okay. And this was originally a jury trial, right?
So it was, yeah. So it was originally a jury trial kind of twice. So they originally called pick the jury. And obviously when you pick a jury, it doesn't immediately start. The jury's picked on one day, at least in Alberta anyways, the jury's picked on one day and then you start on the next day. And what happens when you start a jury trial is they get an opening from the court. So they get told by the justice that's overseeing the trial what their role is, why it's important, things that they have to make sure they do, things they have to not do, and just kind of set out general guidelines for how they should listen to evidence and consider evidence and approach the case generally. And then following that, the Crown would make an opening statement. So they would tell the jury what their theory is going to be, what witnesses they're going to hear from, what evidence they might see, and just give them a lay of the land, if you will, so that they can have an idea of what they're going to see moving forward. Because as you can imagine, if you're a juror who's sitting there, you don't know what the case is about, you don't really have any information, it's hard to go in blind and have no idea what's going on. So that's kind of the purpose of the opening statement.
Yeah, and so anybody following the trial will know that the jury has now been dismissed twice, and now it's a judge who's going to be considering the trial and rendering a verdict.
Yes.
So what happened with the jury dismissals? Why did that happen?
Yeah, so after the opening statement, so the first instance after the opening statements and before things could get going, there was an interaction between one or two of the jurors with members of the defense. They were in line at a coffee shop. There was no real substantive conversation between them, but there was definitely an interaction where it seems like a member of the defense team turned around, recognized that one of them was the jurors, said something. This was brought to the court's attention, and just to make sure that everything was above board, that jury was dismissed and a new one was selected. And then they went through obviously weeks. Obviously the jury was there for all of the complainant's testimony and I think a few other witnesses as well, before there was a note. That's how the juries communicate with the court. There was a note that was handed to the justice through the like basically a sheriff, that says, look, we feel like at least some members of the defense team are making fun of us or mocking us or belittling us or whatever, and we don't think that's appropriate. And so obviously those jurors 100% would have been excused, but then the problem that came to light is, I mean, every single one of the defense teams was like, we don't want a jury. They can only talk to each other. So obviously if these people have this impression, there's a good chance that the others might as well. And that would be really detrimental to our clients. And so ultimately they all agreed to proceed forward, judge alone, and the jury was dismissed.
So this doesn't really pertain to the trial itself, but aren't there any disciplinary implications there or ethical considerations specifically with the defense lawyers?
Like against the defense lawyers?
Yeah.
So I'll have to say from the outset, obviously I'm not the jurors, I haven't been there, but this is a very well-attended case. Obviously, lots of times when you run a criminal trial, there's nobody in the gallery, in the rows behind where people are allowed to sit because criminal trials are public. That's not the case here. This is obviously a very public, very high-profile case. And you know, the judge said she didn't see anything that kind of fell in line with that. The Crown certainly would have raised something if they had any concerns. The other defense counsel would have said something for sure because it is detrimental to their client. So in terms of disciplinary things, at this point it's very difficult. It's just the personal impressions that are kind of written on a note and given to a judge. It's not like you get to quiz them on why they felt that way. But it's also, you know, the defense lawyer, Mr. Brown, he said it would be crazy for us to do that. Because we wanted a jury, we all wanted a jury, and the reason why you want a jury is because you want to be able to show your evidence and your client's case to the jury, and you think that they're going to believe your client, right? That's why you want the choice to go by jury is that of the accused. So the defendants in these cases, all five of them, or at least one of them, would have asked for a jury. And so it would be very counterintuitive, and this is something that Mr. Brown pointed out, it would make no sense for us to do that. These are the people that we need to be on our side. And so to answer your question, is there disciplinary action? I mean, if there was any sort of hearing about it that escalated it, potentially there could be. But no, there's nothing, there's no charge or anything alleged. It's just they said that they felt that they were uncomfortable, and the implications of that were a lot more widespread than I think they would have thought.
So you said there was public outcry, and that's clear. You know, if you look at social media, you look at how the news is covering this case, you can see that it's causing a real strong response amongst the public, where also I think people are questioning some real important institutions in this country, and also somewhat of a cultural underpinning when it comes to looking at, you know, youth sports or youth athletics like Hockey Canada, for example. When you have that kind of a public outcry or media scrutiny, how does that impact jury selection or your trial strategy?
So, I mean, in terms of jury selection, I think particularly even in this case, it would have been very difficult. This was a very public matter even before they were charged. Obviously, the information came out about Hockey Canada having some sort of a fund and using it to settle, I think it's 19 sexual assault claims since the early 80s. And there was a big concern about whether or not public funds were being used, about whether or not certain fees from average players and leagues throughout the country were being used. And so in terms of trying to get a unbiased jury, it's a little bit difficult. And obviously, because defense counsel no longer have peremptory challenges, neither do the Crowns, essentially, unless the judge thinks there's a reason that they cannot sit for the duration of the trial, or the justice thinks that there's a specific reason why they wouldn't be a good juror if they themselves were a victim of sexual assault or had been charged with something previously, things like that, it would be... it's definitely something that I would discuss with my client about what theory that I'm going to be presenting, what evidence is going to come out, what evidence they have to support their theory, would all be something I'd have to consider going towards a jury. The thing about sexual assault cases is they are very much he said, she said, and obviously sexual assault convictions are extremely prejudicial for the accused. They're most likely facing pretty significant jail time. They're going to have a criminal record. And for these people in high-profile cases, obviously, they're never going to play in the NHL again. Their careers are done. I think one of them is working as a construction worker here in Alberta now. Like, his career has completely been derailed, and that's not going to bounce back whether they're acquitted or convicted. And so when considering whether or not I'd choose a jury for that, there's a lot of things that go into it. And I think a lot of it would depend on what my client told me happened, like their version of what happened.
So in your experience, are high-profile accused treated differently by the justice system?
I think high-profile cases are treated very differently by the public, and I do think it does have an impact on how or if they are prosecuted. One of the things that I notice when I'm reviewing the evidence and listening to portions of this trial is there's so many sexual assault allegations that are made every single year, and I'm in no way suggesting that some of them aren't true and that's not valid. But the harsh reality is in most sexual assaults, there is one person's version and the other person's version, and the court's dealt with trying to determine whether or not they can accept either to the point that it's beyond a reasonable doubt. And so a lot of those files resolve. A lot of them resolve by way of peace bonds. A lot of them resolve by way that they just choose not to proceed. And in high-profile cases, I think the likelihood of that happening, even if the evidence isn't great for the prosecution, I think they're not going to do that. Like I don't envy the Crown prosecutors who are running this trial right now at all, because I don't think there's any real room for them to make the call that the evidence just isn't there. At this point, I think it's very clear that they're just going to leave it up to the judge, and I think a lot of that has to do with the public outrage that would come if anything else was done.
Mm-hmm. I do a lot of injury law, and cases will take years to resolve. On average, it can take anywhere between 2 to 6 years for a case to resolve. And so one of the things that I advise clients is that you should probably maintain a pain diary. Just write into it, every couple of weeks so that you can refresh your memory when you need to, because memory is a very fickle thing.
Yeah.
Right? We recall things differently, let's say 2 weeks after something happens versus 3 years after it happened. So how should a jury treat the testimony from an individual who is recalling events that happened, in this case, almost 7 or 8 years ago?
So that is the difficulty. I mean, jurors and, judges alike, they are instructed by the case law that they have to assess credibility and reliability, and then ultimately assessing all of the factors, determine whether or not they accept some, all, or none of the evidence. And in all criminal cases, when you are dealing with he said, she said situations, you are basically testing the credibility and reliability of the witness. And when memory comes into it, you're most likely dealing with reliability, which is quite frankly, I think, the safest avenue of attack. Because if you attack credibility, you're saying you're a liar. You have a motive to do this. You have an alternative theory. You're really coming out as a bad person, or like you're as attacking this person, Versus if you are attacking reliability, you're saying like, look, I just don't know how reliable your memory is because there's been so much time that's passed, because you yourself are saying that you were extremely intoxicated. You have a lot of memory gaps, and it's a common thing, right? Like as a person who's trying to remember something that happens, even if you don't have a very clear memory, you try to fill those gaps. And you fill those gaps often with what you think you would have done, or what you think you would have done if you were in a state that you would have preferred to have been in. For example, a sober state. So there's a number of questions when the complainant was asked, like, you know, what about whether you said this? And it's something that the accused presumably is going to say she said. And she's like, that doesn't sound like something I would say. So she can't remember whether she said it. And she's filling in that gap to say, you know, I don't think I would say something like that.
And she's saying it after 8 years.
And she's saying it after 8 years. And so when you assess that evidence, how reliable is that? You have somebody who says, I can't really remember, who has given varying versions of events, who has not always been consistent in whether she felt that this was an assault or was an assault, whether she wanted to pursue charges, whether she didn't want to pursue charges, whether she was an active participant or whether she wasn't, and this long passage of time. And the fact that she has said, like, I didn't want these charges to be laid. I didn't ask them to reopen my case when they did at this point. Like, she's there because she's been subpoenaed to testify. And so when you consider all of those factors together, how reliable is these very specific details she has? Because those details that she's saying she doesn't remember, or she doesn't think that it doesn't sound like something she would say, those are going to be the differences in about whether or not, you know, there was a reasonable belief in consent.
So looking at sort of the wider opinion within the public, it seems that a portion of the public may have already convicted these hockey players of the charges that they've been, or they're facing now. Now, of course, that's irrelevant when it comes to the question of whether the court ends up convicting them. But do you see any threat to the presumption of innocence?
I think, you know, one of the things that I really struggle with in this case about the presumption of innocence is there's a number of steps that are supposed to be followed, and a number of standards that are supposed to be imposed before a matter gets to trial. And so, you know, this was investigated in 2018 by a senior investigator in the London Police Department. He testified, I think, 2 days ago. When he had this statement from the complainant, and he reviewed some video evidence, and he reviewed the evidence that was provided, he did not believe that there were grounds to charge. And so he didn't go get production orders. He did not believe that there was a reasonable, probable grounds that something happened. And this is an experienced police officer who assessed this. And that's the first hurdle that you have to get over. And it is intrinsically tied to the presumption of innocence, because you can't charge somebody unless you have grounds. You have to believe that something happened, and this officer didn't. And then the charges were reopened again, I think a year later, and they were reinvestigated, and again, charges were not laid. And that means, at the time, they did not think that there was reasonable and probable grounds. And it would be extremely shocking to me if those decisions were made without some sort of advice from the prosecution, some sort of lawyer reviewing it being like, we're probably not there. And so the difficulty with the presumption of innocence in this case is I do think that these charges came about and they were started because of public outrage, because there was so much media attention and Hockey Canada was under so much attention, and then the police force came under attention. And so to, you know, CYA, cover their bases, they reopened it, they laid the charges, and now here we are 7 years later, despite the fact that this isn't a complainant who held off on reporting. This isn't a situation that the police never had an opportunity to hear about it. The police investigated it twice and did not believe that there was grounds to continue. And then once the civil suit came out, once all the public outrage came out, once the information about the settlement came out, all of a sudden, now we have grounds to charge. And that's a problem, because to me, you know, I think there's a portion of the public who thinks that the police didn't proceed because they're one of the boys. They wanted to give these boys a break. They were just having a good time, the whole mentality that you said. And maybe that's true. But the alternative is that they did investigate. In their experience, they didn't think charges should go from the evidence that they had. And instead that they were bullied, pressured by the public, by the government, whatever, to lay these charges because of the public response that happened. And so that means that those standards, those legal standards that are in place to make sure people aren't charged inappropriately, to make sure people aren't subject to the criminal justice system when there isn't a likelihood of them being convicted, that first step has been obliterated. It was just ignored, basically, to relay these charges or to lay these charges so late in the game. And that gives me some concern that the police and, to a certain extent, potentially the Crown's office, instead of reviewing the evidence objectively, there was a lot of public opinion that came into the decision on whether or not to charge these people. And that's really the first branch. And if it can impact the police and it can impact the Crown, then there's always a concern that it will eventually impact jury pools, obviously, and it can get to the point where it can impact courts. Mm-hmm. And so that causes me to have some concern, particularly in sexual assault cases where, like the go-to motto is believe women, believe victims. And, the presumption of innocence is such that you are supposed to start with the belief that these people did nothing wrong. And you can't start with the belief that they did nothing wrong if you are then required to just believe what the complainant says and not give any credence to inconsistencies or unreliabilities or problems that are brought to light through cross-examination.
So where do you kind of see the laws surrounding sexual assault, and not just the laws, but the way that sexual assault cases are handled in the future? If public outcry is sufficient to lay charges in situations where the police or the Crown prosecutor doesn't think that there's enough evidence to lay charges, how do you see the law evolving moving forward?
I think where the law is right now, sexual assault charges are one of the most prevalent charges before the court right now. As when I was a Crown prosecutor, I would say 70% of my cases were sexual assault cases. And a lot of that is because I think, because of the public outcry, because of the Me Too movement, because of the Gomeshi trial and all of these situations, even this trial here, there's policies in place where if a complainant comes in and says these things happen, the presumption is that their evidence is going to be accepted and charges get laid. And so I think the point that we're at now already is that there's not really a critical assessment of the evidence early on. It's the presumption is that they're going to charge and they're going to move forward. And I do think it's a problem, but right now it's a problem that is remedied by the fact that the court still is entitled and required to do an independent assessment of the evidence. They have to be able to explain why someone's credible or not credible or reliable or not reliable and then render their decision. And then there's appeal courts to address it. But, with the way the law is evolving, even into putting the twin myths in Section 276 and putting the documentary requirements from 278 on accused, requiring them to give evidence if they're going to use certain types of evidence in a sexual assault trial. It does seem to be, it's concerning the shift that's there. But, a lot of people describe it as a pendulum, and one point it'll go too far the other way, and then hopefully it swings back to center.
Right. That's the hope.
That's the hope. And, I think just until then, it's just really important for defense counsel to do exactly what they're doing in this trial. I don't think any of them they're not questioning the complainant with the expectation that they're going to re-traumatize her. I don't think they're trying to paint her as some sort of horrific person. They're just simply saying, like, look, your version's not entirely consistent, and at the same time, it's not inconsistent with what my client's saying. And so then where is the consent? And the Crown prosecutor opened by saying that this case wasn't about whether anything happened, because that part's pretty consistent. It's about whether or not she sufficiently consented such that they were entitled to do these activities with her.
So would you take on this case, and what would your strategy be if you did?
So, of course, I would take on this case. Just based on everything that's been said, and it would be just a good case to have throughout your career. It's difficult to answer what my strategy would be because we just heard one of the accused testify today, but it really depends on what your client says to you. But the strategy when you approach any sort of case, but particularly a sexual assault case, is you need to, get your client's version of events of what happened, review the evidence, see where those inconsistencies come into play, and build your case around what information your client gives you to work with. And I think that, but, at the end of the day, in these types of cases where there isn't a lot of other witnesses, where, you know, even with all the other accused, it's not like there's like a video or DNA or any sort of physical evidence that's going to help you out. It comes down to, it's a credibility and reliability assessment. It's going to be whether or not there's an opportunity for you to raise a doubt, a reasonable doubt, that this person's evidence is reliable and credible. And I think that's really the main approach to almost every he said, she said case that you'll come across.
So if there was one thing you could change about sexual assault cases, what would that be?
I think the way in which the law in 276 has developed is very problematic. And I will give you an example. There's a Supreme Court of Canada decision where...
That's the criminal code section for sexual assault, 276?
No, so 276 is the criminal code section that deals with the twin myths, so the prohibition on calling certain types of evidence without permission from the court. And on one hand, I think that that section is very important. I think that there's a very critical reason why it's there, and it avoids people just being ripped apart for potentially making decisions that society wouldn't agree with, and therefore that makes them a person less believable. But on the other hand, you know, there was a Supreme Court of Canada decision that came out about this where there was an accused and a complainant who were basically, they had like a hookup relationship. Like one of them would text the other and say that they were going to hook up or have consensual sex, and on the night in question, that's something that happened. And the information about their prior history, about that being their relationship, about in the past they'd had a number of these interactions before, under Section 276, that wasn't allowed to be canvassed. So the finder of fact was never allowed to know that this is how their whole relationship was this, do you want to hook up? Yeah, I'll hook up. And then they'd meet at someone's house. And so if you don't have that context and then you're faced with an allegation where somebody just texts and says, hey, let's hook up, and then shows up at your house, yeah, you're going to think that they're a weirdo. You're going to think that they were out to attack you and something's wrong. Because if you don't have that context, how are you supposed to assess what was in both parties' minds at that time? And so I think I would definitely change how that's been applied, because I think it puts finders of fact, judges, and juries, it puts them in like an evidentiary vacuum, such that, you know, even if there's a sexual assault allegation between husband and wife, they're not really allowed to know a lot about the prior sexual relationship they had as a married couple leading up to that incident. And that's just not, it doesn't provide any actual context for what these two people may have been thinking at that time. So I think it's definitely swung too far that way.
Yeah, these are tough cases. I remember when I was taking my criminal law course in law school, my criminal law professor said that, you know, it relates to something that people do all the time. And you know, the reason we're all here is because people engage in that activity.
Yeah.
And you know, when you introduce that into the criminal system, an action or conduct that's just so fundamental, and trying to regulate that in a criminal trial is extremely difficult. And I would say that anybody that has a black and white perspective in any case is probably the wrong approach.
Yeah, I mean, for all the reasons you just said, like sexual assault cases are so difficult because the majority of them are not what you think of in a quote-unquote classical sexual assault, which is somebody getting attacked or approached by somebody they don't know. It usually involves gratuitous violence and things like that. Most sexual assault cases aren't like that. And so you're criminalizing something that there is a really fine line, and I think that's why there's so many allegations. I think that's why so many of them get litigated, because it's just really difficult to tell. And the state of the law now with respect to consent, with respect to what qualifies as communicated consent, it gets to the point where, I mean, I have 3 nephews, and I've told my sister, I was like, man, you need to tell them to get like a contract. Like that's the only, like you need, and they got to read it, and it needs to be signed at the end, because then, and even then, I'm not entirely sure.
Send a text message.
Yeah, right. Even then, I'm not entirely sure that would be sufficient, but it has swung quite far to, I'd say, the complainant side, where it is very difficult, I think, to satisfy that test.
Yeah. I mean, you made reference to the civil case, the civil case that this complainant brought against these Hockey Canada players. and Hockey Canada ended up paying her compensation or settlement at least. And lawyers will know this, people in the public may not, but the standard of proof with civil cases is far less than it is with criminal cases. I just find it interesting that the prosecutor or whoever it may have been made a decision in this situation in London, Ontario, to bring criminal charges against these players after, or at least perhaps one of the factors being that Hockey Canada entered into this settlement with the complainant. But yeah, I mean, assault by itself is a tort, and with tort claims, a person who has suffered damages because of the conduct of somebody else or the negligence of somebody else or another party has a right to pursue compensation against those individuals who are responsible for causing those damages. And sexual assault is no different. And what's interesting is that sexual assault in Alberta and a lot of other provinces, the Limitation Act is suspended.
Yeah, I didn't know that. I was talking to you about that earlier today because, one of the things I noticed when I was prepping for this podcast is the dates. Statute of limitations usually around 2 years, and there was a 4-year gap between the 2018 allegations and the 2022 settlements. And I don't practice civil law, as you know. I would never presume to comment on it or give any advice on it because I just don't know enough about it. But that's the one thing I remember from my law school days, and so I was surprised by the date.
Yeah, so the Limitations Act, which says that you have to bring a case or a claim 2 years from the date that you knew or ought to have known that you had a claim, is rigorously applied in most cases except sexual assault cases. And so the Court of Appeal in Alberta considered a case where the reasoning behind suspending the operation of the Limitations Act was that the nature of the assault was such that due to whether it's trauma or shame or the amount of time that it takes a person, a victim or a survivor, the amount of time it takes them to come to terms with that, with what happened to them, it wasn't appropriate to apply the 2-year limitation period. And so, absolutely, sexual assault cases, like assault cases and other tort cases, are claims that can be pursued by individuals if they've suffered damages as a result of somebody else's negligence. But for the most part, you'll see individuals pursuing institutions like Hockey Canada or other big institutions, possibly big corporations, employers.
Which is, I think, what happened here. Like, her claim was against Hockey Canada and a few other foundations. I don't think it was actually against any of the men individually.
No, it wasn't. And part of the reason is because that's where the money is, right? And so, either you're pursuing a corporation or you're pursuing an insurance policy, right? And, I used to do general civil litigation. And part of the reason why I don't do it anymore is because a lot of times when you do general civil litigation for the average individual, you don't really end up providing them with much of a result, right? When I was practicing, big law in downtown, when you represent large multinationals, typically their claims are worth millions of dollars. And so if you're billing them $200,000 or $300,000, you can justify it because their claims, the value of their claims is such that your legal fees are going to be inconsequential. But for the average individual who is pursuing a debt that might be $50,000 or $100,000, if you're billing them $150,000, you aren't really providing them with any sort of a meaningful consequence. And so that's why tort claims, and especially claims against institutions and big organizations, is fulfilling because you end up providing someone with a result. You give them some value, and so absolutely, if with claims that relate to sexual assault, individuals should know that they have the right to pursue a claim. There may be institutions or organizations that are responsible for the conduct of an individual, and compensation can be pursued for that.
So Tahir, it was great talking to you about this. Obviously, this case is a really difficult one and brings up a lot of issues, both in the civil and the criminal context. But we are going to keep track of how it's going, and maybe on the next podcast, we'll let the listeners know, how it ended up and what we think about it. And in the meantime, if any of our viewers have any questions about the civil side or the criminal side, or have any opinions on the case that we discussed, let us know below.